From the Republic Media Network headquarters, it's time for Arnab Goswami on the debate. Arnab Goswami on the debate.
Welcome back, ladies and gentlemen. It's time for the nation's sharpest opinion. There are two sides to the visual that you are seeing on your screen tonight of Arvind Kejriwal getting bail after 6 months. Let's run the pictures in the Liquorgate scam. It is a political victory undoubtedly for Arvind Kejriwal and the Aam Aadmi Party, because the Honorable Supreme Court has said that the CBI needs to dispel the notion of being a caged parrot, and without a doubt these observations of the top court will have far-reaching and stinging consequences in political discourse as far as the opposition is concerned. And in that, it is a sure shot setback for the CBI and the BJP. Second, Arvind Kejriwal's bail order comes on the eve of the Haryana elections, which will give the AAP a big electoral boost that it would have been waiting for. And third, as equally, Arvind Kejriwal bail is not good news for the Congress party, because the Aam Aadmi Party has already ditched them in Haryana. They are getting more politically ambitious in Haryana, and now there is likely to be a split in the anti-BJP vote, because Arvind Kejriwal will give everything at it now that he is out. Anyway, things are not going swimmingly between AAP and the Congress party. So this could, in a way, have politically some benefit for the BJP. However, legally, and this point has to be made, this is no exoneration for Arvind Kejriwal and what he may have done. There is no clean chit. The Supreme Court, across its 60-page order, has nowhere said that there is no case against Kejriwal, there is no evidence against him. So legally speaking, Kejriwal getting bail doesn't water down the allegations or the findings, and certainly does not make Liquorgate scam go away. In fact, with the Supreme Court saying that the arrest was not illegal, establishes that there was no procedural irregularity as the AAP was claiming. And then beyond this order, there is still no clarity whether Arvind Kejriwal deliberately tweaked and manipulated the now scrapped controversial liquor policy. There is no clarity on that. Whether Arvind Kejriwal got a share of the profits from wholesalers, there is no clarity on that. Whether Arvind Kejriwal's campaign benefited through the proceeds of crime. There is still no clarity on whether Arvind Kejriwal or his party demanded kickbacks from the quote-unquote South group of 100 crores and more. So, in a way, beyond the visuals on your screen and how it will play out politically in Haryana, remember, viewers, this is a case of alleged political corruption. And that case, Liquorgate, legally continues to be very much there. And Arvind Kejriwal will have to prove his innocence against the findings of the agencies. So, viewers, that is my view on today's developments. We are going to have a very pitched AAP-BJP debate I'm starting with tonight. And then we are going to open up the debate as well. You decide which way you stand, viewers. Here is the story of the day.
लेकिन हर कदम पे भगवान ने मेरे साथ दिया।
6 months after his arrest by the Enforcement Directorate in Liquorgate probe, Delhi Chief Minister Arvind Kejriwal has been granted bail. While granting bail, the Supreme Court made some pointed observations.
Observations made by Justice Suryakant, Supreme Court. No impediment in arresting someone already in custody. Remember, Arvind Kejriwal was first arrested by the Enforcement Directorate, and thereafter, once his custody was exhausted, the CBI had taken over and arrested him. Observations by Justice Bhuyan, CBI's appearance. Now, he has questioned CBI stepping in and then arresting Arvind Kejriwal. So, CBI's appearance raises more questions than answers in this case. That's what Justice Bhuyan had said.
The bail was granted on some conditions. The Supreme Court directed Kejriwal not to make any public comment on the merits of the case. Kejriwal will also not be allowed to perform his chief ministerial duties, visit the CM office or the Delhi Secretariat. In his bail tenure, Kejriwal will also not be able to interact with any witness. And while the Aam Aadmi Party is claiming vindication, the BJP says that Kejriwal has yet not been proven clean.
आज माननीय सुप्रीम कोर्ट का आदेश भारतीय जनता पार्टी के मुंह पे एक कड़ा तमाचा है कि आप एजेंसियों का दुरुपयोग कर रहे हो। आपने एजेंसियों को अपना केज पैरट बना के रखा हुआ है। ऑनरेबल सुप्रीम कोर्ट ने बहुत साफ शब्दों में कहा कि सीबीआई केज पैरट की तरह से काम कर रही है।
6 महीने तक किसी संवैधानिक पद पे कोई व्यक्ति बैठा हो, उसके लिए तो एक दिन अगर वो जेल चला जाए तो बहुत बड़ी बात होती है, इस्तीफा दे देना चाहिए। यहां 6 महीने तक जेल में रहकर आए और आज कंडीशनल बेल मिलने पर भी इस्तीफा नहीं दिया है।
Kejriwal is the third AAP leader to get bail in Liquorgate scam after Sanjay Singh and Manish Sisodia. Who benefits from Kejriwal getting bail?
We have 1 versus 1 to start with tonight. Anmol Pawar, spokesperson of the AAP, and Shazia Elmi, spokesperson of the BJP. My first question is to Shazia Elmi. Justice Bhuyan said, such action on the part of the CBI raises a serious question mark on the timing of the arrest rather on the arrest itself. For 22 months, CBI does not arrest the appellant, but after the learned special judge grants regular bail to the appellant in the ED case, CBI seeks his custody. In the circumstances, a view may be taken that such an arrest by the CBI was perhaps only to frustrate the bail granted to the appellant in the ED case. So, first point is ED gives bail, you get a case on the CBI immediately, and the timing is with the ED getting bail. The first charge by the court is therefore the CBI's intentions was to somehow keep him in jail for a longer period of time. You need to answer that first.
So first of all, I'd like to say that both the judges had a different point of view, and Justice Suryakant held that the arrest of Arvind Kejriwal was valid and legal. But if you look at the order itself, you realize that yes, he has been granted bail. It is with conditions, and that does not in any way.
But the court
mean
has also
that he
gone on to say, like Caesar's wife, 1 minute, like Caesar's wife, an investigating agency must be above board. Not so long ago, the court had castigated the CBI, comparing it to a caged parrot. Allow me to complete, because I don't accept that view of yours, Shazia. The point the court has made, Shazia, there's not hullabaloo. It is observations of Justice Bhuyan. There's no hullabaloo.
More than one case.
You have no regard for the Supreme Court.
My question is, Anmol, 1 minute, let her answer my second question. Shazia, please. Exact words, like Caesar's wife, an investigating agency must be above board. Not so long ago, this court had castigated the CBI, comparing it to a caged parrot. It is imperative that the CBI dispels the notion of being a caged parrot. Rather, the perception should be that of an uncaged parrot. These are very strong observations.
These
right?
are very strong
Yeah.
observations.
You can't dismiss them.
I do not speak at all either for the CBI or ED. Yes, I speak for
You
my
are dissociating
party and its
from
policies. But
you
I'd
are
like
justifying
to say, this
everything
has been said
so far.
before. It is a shame that nothing has changed. But it has been said before in UPA 2 of the Congress party. And that is a party Arvind Kejriwal has decided to go with, not once but many times. So it's hardly something they can use, throw it in our face, because they have totally been a part
Anmol,
of that setup where the same thing was thrown at the CBI.
Anmol, would you like a
1
minute rebut or face my question?
What face would you...
Will you take a rebut or take my question? Then I'll give you a 1 minute rebut here. But you'll have to give her a rebut as well.
And condone yourself, having been partnered with Congress so many times over, for whom the same observations were made in very serious
don't bring
and
Congress
ambiguous
here.
terms.
They have other issues. Let's remain here. He wants to rebut you for a minute. I allow a 1 minute rebut. 1 minute only, Anmol. Yeah.
Shazia ji is very agitated today. Because today by...
Not at all. It's all happening in your mind. Look at me. I'm the picture of calmness and composure.
Can I respond? Arnab, today by granting bail to Mr. Arvind Kejriwal, the Honorable Supreme Court has unequivocally affirmed that Constitution of India stands above everyone else. संविधान जो है वो supreme है इस देश का. The Supreme Court further clarified that the CBI's arrest of Mr. Arvind Kejriwal was a deliberate attempt to keep him behind bars because he was granted bail by Enforcement Directorate case, and he was granted bail thrice, first by the regular court and twice by the Honorable Supreme Court, interim bails which were granted. And this attempt...
And how many times was he denied bail by the same court?
Please allow me to complete. Today, furthermore, the Honorable Supreme Court also said that this arrest by the CBI was part of an orchestrated conspiracy which was hatched.
Anmol, now your 1 minute rebut is over. You used it to make an opening remark, which I need to intervene and ask you my first question, please. Anmol Pawar, spokesperson of the AAP, the simple question that I have for you is this: that if your leader Arvind Kejriwal has indeed been exonerated, as you claim he has been, why has he been told strictly not to step even to his office in the Delhi Secretariat? And why has he been told not even to sign files?
Arnab, para 43 of the judgment, I must read it for your viewers, wherein Justice Bhuyan said that though I have serious reservations on clauses B and C which debars the appellant from entering the office of Chief Minister and Delhi Secretariat as well as signing files, he has very serious...
Which page is that?
Reservations on it. It's page number 31. It's page number 31. Read it for your viewers.
Okay, No, 1 minute. No. I'm telling you where you're wrong. 1 minute. Let me just see, please. You see, when you make a point, let me explain to you where I believe you're wrong. Please look closely, more closely than you're looking at, into the order of the Honorable Supreme Court, and where Justice Kant holds that the arrest of Arvind Kejriwal was legal and did not suffer from any procedural irregularity. I allowed you to make your point. Now you hear mine, where the Honorable Court says there is no merit in the contention that the CBI failed to comply with the mandate of Section 41/41A of the Code of Criminal Procedure while arresting him. And in fact, the bail was granted solely on the basis of Article 21, which says that continued incarceration for an extended period pending trial would infringe upon established legal principles and the appellate's right to liberty, traceable to Article 21 of the Constitution. And then it comes with terms and conditions applied. I know it because my case was cited also by the Supreme Court here.
No, but you haven't. My
own case was cited by the Honorable Supreme Court, so I'm aware of what the court said.
You haven't read para 43, page 31. Please read it for your viewers. Do you mean that the observations made by Justice Suryakant stands on a higher pedestal than made by Justice Bhuyan?
Okay. Now, can I respond? Can I respond to you, Anmol? Can I respond?
Yeah.
No, but I have a question. Why would see where the matter of where the excise policy goes and all the charges that go with it, and when there is not just implication but actual charge sheet of wrongdoing. There is no bail on that merit at all whatsoever. It is only because it's a matter of civil liberty, and the judges quote that and say it
Anmol,
a few times that it
Anmol,
is a matter only because
Shazia ji,
should be an
today
exception.
the Honorable
So why would
Supreme
we
Court
presume, and
exposed
what
the
is there to
unholy
celebrate? The trial will begin
nexus
soon.
of the ED,
fact of the
CBI
matter
and the
is that
Bharatiya
Arvind
Janata
One
Kejriwal
minute.
cannot
Shazia, one
be-
minute.
they have
Shazia, I have a question to follow up to what I asked Anmol, because we were on a very strong legal and technical point. And my question to you, Anmol, is this: that Anmol, I think you are being extremely unfair, and you are being extremely discourteous. Anmol, you are being discourteous and unfair to the highest court of the country, which you should not do. I must only caution you by making it look. Allow me. Because you tried to make the point of view of Justice Kant out to be a dissenting judgment. It was not. Both the judges were in complete and absolute agreement.
I would
like you to stop doing that.
I would like you to read it out.
I would also like to read it out. Okay, can I ask you, am I right or wrong? One, that Arvind Kejriwal shall not visit the office of the Chief Minister and the Delhi Secretariat. Was that a joint view of both the judges or not?
Can you please read out page 31, para 43 for your viewers?
Yeah, can you please, I 100% will do that, but can you please read out exactly what is written in the final decision of the Supreme Court in the criminal appellate jurisdiction of Arvind Kejriwal versus Central Bureau of Investigation, page number 2. Page number 2, kindly have a look at it. Have you got it before you? Thank you. Thank you. And is it a joint view that he shall be bound by the statement made on his behalf that he shall not sign official files unless it is required and necessary for obtaining clearance/approval of the Lieutenant Governor of Delhi? And he shall not interact with any of the witnesses or have access to any official files connected with the case.
I can read that on page.
Yeah.
Arnab,
you're getting confused now. You're getting confused.
No. I'm not getting confused. You are trying to evade and not reading that particular paragraph because you know that Justice Buyal has made very specific observation that he has serious reservations on both these conditions, which debars a sitting Chief Minister to not go to the Secretariat or sign any files. Why are you not reading it for your viewers?
I will read out.
I've asked it for the fifth time. Or should I show it to you on screen?
I want to ask you
Do you want me to show it to you on screen?
There are observations that are made. There's also proper judgment.
Shazia ji,
it has to be concurrent.
See,
two judges in a two-judge bench.
Shazia, 1 minute. Shazia, 1 minute. I also would like to bring your attention, Shazia.
And there was nothing illegal about it.
Shazia, the respondent,
the court says, concerned, they will be discussed and there will be a trial that will be done.
Shazia, I want to read out to you.
Shazia ji, the fact is that what we have long asserted that CBI and ED have been acting as mere puppets of BJP. Today the Supreme Court confirmed that CBI operates like a case parrot. And the moot question is,
you are claiming to be Khattar Imandar.
It is none other than Home Minister Mr. Amit Shah. Mr. Amit Shah.
No, but Shazia, a point being made here. Can I also bring in? Can I bring in? I bring in here nice poetry tonight. Now my question tonight is this, Shazia.
This is the fact. The constitutional machinery is compromised by none other than the Home Minister, Mr. Amit Shah. And he must resign.
I would like to ask you, I really like your tonality, but Anmol, I would like to ask you, I would like to ask you a question. Please listen to me. I'm opening up right now. I would like to bring your attention to page number 19, point number 30.
Arnab, but you will not read that. You will not read that para 43.
I will. Because I am.
It is the sixth
Anmol, I am asking you repeatedly.
You will not read para 43.
Okay, here's a point to you. What did the Supreme Court say when I was arrested by the Congress government?
Are we discussing your case?
Yes, we are. Because page number 19, Supreme Court refers to my case.
Or are we discussing the bail of
in this judgment, have you not seen the bail order where they refer to my case? Are you blind? Do you not see what the Supreme Court refers to? I'll open. Yes, we are. I'm not discussing Supreme Court in the context of Kejriwal's pleas referring to my case. It's a known fact. And the court says, Anmol, listen. Anmol, listen. Anmol, everybody watching the program tonight must listen to this. Where was Arvind Kejriwal and Anmol and Congress's empathy, right, when the case of Arnab Goswami versus Union of India happened, where the court today says, please take a look everyone on, the court reiterated the role of the courts in protecting personal liberty and ensuring that the investigations are not used for a tool of harassment. Referring to its earlier decision in Arnab Ranjan Goswami versus Union of India, Appendix number 5, the court observed that the court should be alive to both ends of the spectrum. The need to ensure proper enforcement of criminal law on the one side, and the need to ensure that the law does not become a ruse for targeted harassment on the other.
Fair investigation is a fundamental right.
Oh, right. When it comes to you, you're investigating. When it comes to others, they're harassing. Ishkaran is opening the debate on the other side tonight. Ishkaran Bhandari, the debate is open.
And Arnab, Arnab has spoken enough. Now it's my turn. I didn't interrupt anybody. First, Arnab, on the lighter side, you're already wearing a black coat except a tie. I think it's high time you get the band the way you're quoting page number, paragraph number. I feel it's still afternoon, I'm in court. But anyways, coming to the Arnab, one serious issue. Aap government just a few days ago banned firecrackers in Delhi, and they said it causes pollution on Diwali. 1 second, don't interrupt. We are citizens of this country. We are residents of Delhi. We have the right to speak on Delhi issues also. Few days ago, they banned firecrackers. They banned firecrackers to be burst on Diwali. Today, Kejriwal gets bail, and they burst firecrackers. Is Mr. Kejriwal's bail bigger than Diwali, or suddenly there will be no pollution and you don't want crackers on Diwali? And when Diwali comes, please save my clip. I want this to play when they pass orders of banning crackers on Diwali. How are they allowing crackers in Delhi on his bail when they want it not to be burst on Diwali? And I want to read Mr. Gopal Rai, their Minister for Environment. He says, the Chief Minister, last year, he says that the Chief Minister does not want, 1 second, I will read it verbatim. The Chief
शाजिया जी से ज्यादा बुरी हालत आज
on Diwali.
आप तो प्रवक्ता भी नहीं हो बाजू.
CM Arvind Kejriwal has decided. Don't interrupt, Arnab. This needs to go out. This is important issue, Arnab. CM Arvind Kejriwal has decided firecrackers should be banned on the
Okay, but to be fair, can I come in? Can I come in and continue to quote? Can I continue to quote para, chapter and verse from the Supreme Court order? Thank you. I'll discuss the firecracker ban later. Ishkaran, don't derail the debate.
I don't see that.
My point is, and BJP should accept tonight to some extent. Please. I have ML Sharma, former CBI director. I don't want to keep him waiting. He's there on the debate as well. Mr. ML Sharma, what in your view is the implication of the fairly strong criticism of the CBI in this case, where the Supreme Court says the CBI must dispel the notion of being a caged parrot?
Arnab, you have gone through the judgment very thoroughly. This is the impression that I get. I have also cursorily gone through the judgment. Actually, it's not one judgment, there are two judgments. In Justice Surya Kant's judgment, there is no such mention, cage parrot and all that. Only that thing he says is that arrest is lawful, but he has given bail to Kejriwal primarily on the ground, DC para 39, that there are 234 witnesses and therefore trial is going to take a long time. And the legal philosophy that our judges are having these days, liberty and things like that. Now, if I go to the judgment of Justice Bhuyan, I find that he has held arrest to be unlawful, but mainly on the ground that the arrest was made more than 2 years after the registration of the FIR. Factually, it is true, but this cage parrot reference, I think para 29 or something, he has borrowed this expression from a former Chief Justice of India, to me, frankly speaking, even though I am very respectful for the Supreme Court and judges, I mean, it's not a very apt and correct thing to say. The investigating agencies have carried out the investigation. Please remember that in both the judgments, not even a single word has been said about the merits of the case. This being so, this expression, use of this expression, to me appears to be totally incongruous.
So this observation itself doesn't amount to much. You're saying that, Mr. Sharma?
It doesn't.
It doesn't amount. So,
it doesn't.
So what happens in terms of the impact on the trial?
Because I have given the reason. It will have no impact on the trial if ever trial takes place. Also,
Mr.
please
Sharma,
remember.
But having said that, having said that,
Court has emphasized
having said that,
acting like a caged parrot.
having said that,
Perception
has the
matters in a
CBI not
functional
delayed?
democracy.
Has the CBI not delayed the case too long? I mean, that aspect has to be looked at. I want to bring in Savio as well as Kapil Madan on that particular aspect. Has the case been delayed for too long? If this was a case when, you know, it was an open and shut case, Savio and Kapil, then it should have been closed up by now. But the case has dragged, both the timing of the arrest, the time it is taking after that, right? And the judgment delivered by Justice Ujjwal Bhuiya, who is more critical of the CBI, says that the CBI filed a total of 4 charge sheets wherein 17 persons were named as accused. Manish, Sisodia and K. Kavita were named as accused among others. Appellant Kejriwal was not named as an accused in the said charge sheets. Fifth and final charge sheet was filed on 29/7/24, wherein the Kejriwal has been named as an accused. And he also said non-cooperation in the investigation is not a ground for arrest. So the issue right now, the point I'm making, Savio, Kapil, the issue right now, 1 minute, Kapil, I'll give me one line, don't be. The issue right now is not about the merit of the case against Kejriwal. That's where the AAP may be mistaken in celebrating early. The issue is the right of an individual facing a trial which may be prolonged to get bail in the interim.
No,
one minute. I want to highlight it further. One sec. See, Anmol, the court has referred to my case and everybody says, and I'll put this on record, everybody says, 1 minute, Anmol, listen to me. Anmol, listen to me. Anmol, listen to me. Anmol, listen to me. Listen to me. Anmol, listen to me. Anmol, listen to me. I know you want to go to the political debate and not the legal debate, which I don't know why. But you see the difference, with all respect to the Honorable Supreme Court, which is, must be aware that they are court. Anmol, calm down.
These are the issues.
Okay, the issue here is, the court has nowhere said there is no prima facie case. I place most humbly before the people of this country, and I want to say this. Please let me complete what I'm saying this time. Everybody on. Shazia, wait a minute. Shazia and Anmol, wait a minute. I just say one thing and then you guys carry on. No, you both wait a minute. No, both of you wait a minute. No, be patient, Shazia. Shazia, let me make my point. Shazia, 1 minute, guys. 1 minute. 1 minute.
It's an important
Kapil, I will come to you. Anmol, and okay, I'll reduce the audio. If none of you are going to listen, I'll cut your audio for a minute. Listen to me. And Kapil, all I'm saying is I'm giving it to you, Kapil. Just wait a minute. I'm giving it to you. The point that needs to be made is this. The court has not said, just okay, come back. Audio need not be cut. Just wait a minute. Let me be patient. The court has not said there is no prima facie case. With greatest of respect, I thank the courts for referring to my case. However, for the purpose of discussion, it must be emphasized that Justice D.Y. Chandrachud, when he gave the order in my case, said there is no prima facie case at all against Arnab. Justice Bhuiya also has not said that now. So there's a world of difference. You get my point?
Exactly,
Kapil, go on.
That's the point I'm trying to
so
make.
let me just give very
quick response. It has nothing to do with merits of the
Justice
case.
Suryakant's judgment. What did Justice Suryakant observe? He has mentioned and have observed.
Whose judgment are you reading? Whose judgment are you reading?
So I am reading Justice Suryakant's judgment, para 33. What has been said? In a functional democracy governed by rule of law, perception matters. Like Caesar's wife, an investigating agency must above board. Not so long ago, this court had castigated CBI, comparing it with a caged parrot. it is imperative that CBI dispel the notion of it being a cage parrot. Rather, the perception should be of that of a uncaged parrot. Now, I will refer to the judgment authored by Justice Bhuyan on arrest, which is the most important observation authored by Justice Bhuyan. What he says in para 23, he says for 22 months, CBI does not arrest the appellant, but after the learned special judge grants regular bail to the appellant in the ED case, CBI seeks his custody. In the circumstances, a view may be taken that such an arrest by the CBI was perhaps only to frustrate the bail granted to the appellant in the ED case. Now,
but does this say the arrest was illegal?
No,
1 minute. Does this mean as the court says the arrest was illegal? Kapil, counter question. Has the court said the arrest was illegal?
Oh, just a minute. Now,
why don't you answer? As the court said the arrest was illegal.
What has been said in para 43? In para 43 also, since the judicial discipline demand, one bench of equal strength cannot give any, contradictory judgments of a different coordinated bench. All the court have done is the court have raised concerns about the conditions of the bail. That is clause.
My point here is now, okay, Kapil, let's keep it short. I'm getting everybody in. I'm getting everybody in. Kapil C. The BJP, Savio.
If you now
complete your point.
See the ED case. He has got
you have to complete your point. You can't. You're making a stream of consciousness argument.
The main thing that we need to look at, Kapil, allow me 30 seconds, is the insinuation of the Supreme Court towards the CBI and terming them as cage parrot. And that is a very important aspect because a lot of the cases that are currently being investigated by CBI, some of them are political people, some of them are socialites.
I can't say. I will not quote para without the paper and
that have not reached a final conclusion. And that is one of the reasons why people are losing faith as far as the CBI and ED are concerned, even though they are doing a good job.
No, but Savio, that doesn't explain one point. That doesn't explain one point, and I want to ask Mr. ML Sharma that. Sorry, that does not explain a point. The question is speedy trial or prolonged trial. My problem with the CBI always has been, it takes a case and then sits on it, does nothing. What has the CBI done in the SSR case?
Precisely.
1 minute. What has the CBI done in the Sushant Singh Rajput case? Exactly. What has the CBI done so far in the RG Kaur case? The feeling one gets is that the moment a case goes to the CBI, it goes into cold storage. And that, Mr. Sharma, has become a weakness of the CBI. The court has also said, if the state prosecution agencies, Shazia also, and ML Sharma, or even courts do not have the wherewithal to protect an accused's right to speedy trial, they should not withhold bail on the ground that the crime was serious. So the question is, why did the CBI not move fast? And why did it not move earlier? Why did it move after the ED denied bail? Why were you timing it like that? What was the purpose? Was there coordination between ED and CBI? You finish your period, then I will begin mine. How fair is that for the accused? Mr. Sharma.
Yeah. See, the statements that you have made, I just don't agree with that. CBI is like Supreme Court is the last court in the country. CBI is the last agency as far as investigation is concerned. And please remember, I am distinguishing between CBI and ED. I am not for them. And I have nothing much to say about them. See, a lot of reflection, a lot of thought has to be given to the investigation. And also please remember, after arrest, charge sheet has necessarily be filed within 90 days in serious cases and 60 days in other cases. Your statement that what CBI has done in Calcutta case, frankly, I don't have any personal information, but I can guess what they have done. You see, investigations in serious cases like this that you are mentioning are not conducted for public consumption. They are conducted for the satisfaction of the trial court and the higher courts. So, therefore, this kind of general statement is not correct. Basic issue which this country has not understood so far, and I can say it with all the authority that I command, that the trial process
is very slow. And please remember, I don't blame the judges. The number of judges in this country is too small. 5 crore cases pending, and you have only 18,000 judges in position. If you go by the reports of the Law Commission of India, this country needs about 1 lakh district court judges. Unless this happens, the criminal justice system will go down and down and down, and it will never improve. As far as Sushant, Bombay case is concerned, see, the opinion given by, this is my personal information, opinion given by the All India Institute of Medical Sciences about the cause of death, of course I have no access to it, but I can guess, has settled the whole matter. Only thing is,
nobody trusts
to that extent
I
agree with you.
I had put
that
out
CBI
WhatsApp information with the officials, relevant officials of All India Institute of Medical Sciences, where they had contradicted this fact, and that was not investigated. It's basic level information, but problem is CBI chooses not to see things that are not convenient to it. Anmol is responding to that issue, sir, from the other side. Anmol.
Arnab, the fact is that when the bail was denied earlier to Mr. Kejriwal, the BJP spokesperson and political analysts from Bharatiya Janata Party used to shout at the top of their voice that if he were truly innocent, then bail would have been granted. And now that bail has been granted, not just once, not just twice, not just thrice, but 4 times. Once regular bail in Enforcement Directorate case, twice interim bail by the Honorable Supreme Court, and now in the CBI case, they trivialize it with saying that it's just bail. So
let him complete.
I remember one saying in Hindi कि खिसियानी बिल्ली खंबा नोचे. तो आज इनकी हालत वही है. This fits their reaction perfectly today. Because they are rattled, because they are visibly upset by the release of Mr. Arvind Kejriwal, because they know कि भाई साहब शेर बाहर दिल्ली में इन्हें धराशायी करेंगे अब चौथी बार भी. And they know that these conditions which they are referring to, when they are reviewed by the bench, they would be set aside. शाजिया जी बहुत परेशान हैं आज. मेरी संवेदनाएं आपके साथ हैं. My sympathies are with you. You cannot answer anything today. And the at least now you have to face the reality that even the Honorable Supreme Court has exposed you.
Why are you claiming
that CBI is a caged parrot working on the instructions of the central government?
There's nothing to do with
that the truth. They must dispel this notion that perception matters in a democracy.
In this case,
that the rule of law must prevail.
But on the Anmol, if I may, can I just come in? Anmol, since you respect the court so greatly, would you also agree that the High Court noted that a statement recorded on May 20th, 2024, a day before his arrest, contained material that prima facie seriously incriminated Arvind Kejriwal in that case? That does not change with the getting of bail.
Arnab, the trial has not even commenced.
No. But prima facie, what did the Honorable Appellate Court say? The Honorable Appellate Court said that there was prima facie incriminating evidence.
Why would he presume that he's not guilty?
I am answering your
question. Why are you
question.
saying Satyamev Jayate?
Please,
what is this to do
I am
with
answering
merits
your
of the
question.
case, of the excise policy
as far as PMLA is concerned,
how would you? Why would you tolerate him? At least
person is presumed guilty until proven innocent.
So you're lying through your teeth and you say.
1 minute, don't speak over each other, please. Anmol, she's countering you. It is better if you don't speak over each other. I promise you, I'll give both their time.
I got you on that.
I'll come to you, Anmol, after she finishes.
The trial has not happened. Then why would you feign honesty? And why would you say there is no wrongdoing and there is no corruption whatsoever? Because this is on the basis of personal liberty and quoting of Article 21.
Shazia, can I just 1 minute. Shazia, listen now. Shazia, don't speak over me, please. Shazia, you must understand. Shazia, listen to me. You celebrate every time one of your leaders gets bail. Even when Akash Vijayvargiya, who was arrested for thrashing a municipal official with a cricket bat in 2019, was granted bail, right, son of your senior leader, he was received with garlands and sweets as if he had achieved something major. 1 minute.
It was taken very, very badly.
No, you have, no. My question is, Shazia, listen to me. Shazia, I am only saying, and you need to listen to me, that the BJP has very often taken bail, Shazia, why don't you listen? Shazia, 1 minute, Anmol. Shazia, I'm saying the BJP has taken the granting of bail to be an exoneration when it comes to its own leaders. Anmol, my question to you. Anmol, my question to you. Anmol, my question to you.
Can you repeat, Arnab? Can you repeat your question?
Yeah, when you listen to me.
No wrongdoing was
done. I'm listening to you.
No corruption happened. No kickbacks happened. That the entire policy was not tweaked, and all the license fee and the commission was not taken. Can that be proven? That has not been proven. So why are you taking a victory lap? I think you're just hurrying up and just giving this impression, knowing very well that a long trial is pending.
With the use of CBI and ED, you maneuvered this illegal arrest using this CBI.
And whether it's a wholesalers or the monopoly and the South group are not involved. You have yet to prove that, my dear friend. This is only about Article 21 and personal liberty, the basis on which Kejriwal has gotten out. It has nothing to do with the massive liquor scam.
You want a person to pronounce guilty even before the trial has commenced. Do you have even basic
and you want to
understanding
pronounce him innocent before he's commenced?
Do you have basic understanding of
Anmol, I'm very well aware of the rules. Now I shall argue on the merit of the case, and I will bring in Mr. ML. 1 minute. Anmol, you're not taking a question. You're not letting me intervene. Then you just want to have a monologue. That's not right. 1 minute, please, Anmol. Anmol, you listen to me. Anmol, आपको तो सवाल लेना पड़ेगा ना. बिना सवाल लिए कैसे चलेगा?
जवाब तो देने दीजिए ना.
अरे सवाल ही नहीं पूछा, आप किसका जवाब दे रहे हैं?
नहीं, आप वो कुछ भी
मैंने सवाल ही नहीं पूछा है, आप मेरे सवाल का जवाब दीजिए. शाजिया, 1 मिनट रुक जाइए, मैं सवाल पूछ रहा हूं आपको. See, first of all, we must not show disrespect to any court. Appellate court, Delhi High Court, April 2024. See, people are asking what happens to the case. Has he been declared innocent? See, the Honorable High Court recorded a prima facie finding. Justice Swarnakanta Sharma recorded a prima facie finding, right? Said that Arvind Kejriwal was...
High Court judge's order over a Supreme Court judge's order. I don't know what is the basic...
Why are you out of your mind, Kapil? Kapil, don't you understand? I understand whether you've completely lost your mind or you're pretending to.
No,
because I am only mentioning. Can you listen to me? Can you listen to me? Don't give me this childish logic of Supreme Court over High Court and High Court over Supreme Court. I am saying on the merit of the case, what have the court said? You show me one finding or one comment on the merits of the case in what the Supreme Court judges said today. No, one. You see, I am making an argument on the merits of the case. And you know that you are on weak ground, so you are trying to stop me. But we must ask ourselves some very deep questions on the merit of the case. And Kapil, can you be quiet?
Has said that CBI has done the arrest only to frustrate the bail granted in the PMLA case.
I agree on the bail issue. I agree with what the court has said. Savio, be quiet.
Not acquitted.
Savio, 1 minute. Kapil, I take your point. Now let me respond to you.
Then I think you have lost all the mind and senses to quote the High Court judgment, because the High Court judgment is merged with this.
Where did you do law, Baba?
Subject,
did you study law?
Which is a final judgment until and unless a review or
I don't think you've studied law.
I am sure.
How did they make you a member of the bar here?
I am sure, the CBI would want to challenge this. But unfortunately, as of now, the judgment
don't get prickly.
The judgment remains, and it says that CBI has done the arrest only.
1 minute, Ishkaran, be quiet now. I'm responding to him. Let him finish first. Okay, he's finished now. He's finished. Ishkaran and Savio stay out of this. Let me explain to Kapil. Let me explain to him like a child. 1 minute. Ishkaran, be quiet now. Ishkaran, I won't let you come in now.
No, hold on.
I have to explain to you like a child. You have to be explained to like a child.
PMLA court has said. During the PMLA proceedings, the AHJ has said sometimes they give lollipop to get and obtain evidence from the approvers. this is not my word. This is recorded in the order said by the Honorable ASJ, who was also representing the government in the Supreme Court. They gave lollipop to get some evidence against the.
Now you must be. Now I request you to be quiet. Kapil, I'll cut the audio now because I'm stepping in. Now I'm explaining something to you so that you're not lost in your own ignorance. And I would like to make a couple of points which would be of very great interest to both Anmol and of course Kapil Madan. I don't know where he did law. Please, professors, whoever taught him, disown him today. See, viewers, there are 2 points here. A comment made on giving or granting bail, or the need to give bail, or the right to give bail. 1. Second, comments made on the merit of the case. These are 2 wholly different things. My point being that in some cases, the court, while granting bail, makes observations on the merit of the case. Like Honorable Present Chief Justice of India, volume down, please, producers. He has to be restrained right now because he's not listening. Kapil, in my case, the Honorable Supreme Court commented on the merit of the case and said there's no case. In this case, that has not been the case. And since you're quoting the Supreme Court, have you heard of Justice Sanjeev Khanna, April 2024, regarding Kejriwal's refusal to give statement to ED, said, are you not contradicting yourself by saying that his statements under Section 50 of the Prevention of Money Laundering Act were not recorded? You don't appear on summons for recording of statements under Article 50 and then you say it was not recorded. If you do not go for recording of Section 50 statements, you cannot take the defense that the statement was not recorded. Now further on the merits of the case, Justice Swarnakanta Sharma recorded a prima facie finding, and I quote, that there was adequate material including statements of approvers, involvement of middlemen, and references that cash was handed over for expenditure in the 2022 Goa Assembly elections. That's my submission. Yes, Kapil, I hope you understood. Sorry to give you a little coaching class. Volume, you can increase the volume.
And I really don't want to, question you in that, because you are not a lawyer. You are facing cases. That's another thing.
You are lucky I'm not a lawyer.
You're not a lawyer. Of
you
course,
are lucky
yes.
I'm not a lawyer.
So therefore, I don't expect this technical, knowledge from you. Section 50 statement can't be read against the accused. Section 50 statement is not an admissible piece of evidence against the accused. If you really want to test this, just Google. This has been said by Justice Gavai last week only. So this is in Prem Pal's judgment. You just go Google, read it, you will get it what I'm saying. Now this is where we are. Now insofar as this case is concerned, I have quoted the judgment, the observation made by the Honorable Supreme Court.
No, I am only telling you, and what Anmol will also agree with me, is that in the past, since you are not in a way, you are not a good lawyer then, Arvind Kejriwal, my point is, has faced judicial criticism with both the Supreme Court and the Delhi High Court, raising serious concerns about his involvement in the ongoing investigations.
You don't have an answer.
Why are you speaking over me when you don't know? You don't have experience, you don't have knowledge, you don't know how to connect 2 things together. You're only proving your naivete on my program.
That's the only thing you can do. When you don't have an answer on the merits, you will make personal...
I am only questioning you on the merits. I am repeatedly mentioning on the merits. Anmol.
The fact remains, you are unable to answer.
You have not made a single point on merits of Anmol.
Kapil is getting to Anmol.
Because you don't have an answer.
You are referring to all the orders on this earth to justify your point, and this is not how it works. The fact is that you are referring to a Delhi High Court order passed in this matter, but please refresh your memory that the orders passed by the same bench, with all due respect, were overturned by the Honorable Supreme Court in Manish Sisodia ji's case, in Sanjay Singh ji's case. And the entire reason was demolished by the Honorable Supreme Court. So this is what will happen in this case also. It will also meet the same fate. And as far as bail is concerned, see, in PMLA case...
But is there a lesson in this for BJP?
I need 10 seconds. I need 10
seconds.
Yeah, okay. As far as PMLA is concerned, an accused is considered guilty until proven innocent. And it is at the very initial stage, at the stage of the bail, that he will have to prove his innocence. And because Arvind Kejriwal ji has prima facie proved his innocence, that is the reason why he's outside.
The focus, whether one likes it or not, Ishkaran, the focus whether one likes it or not is going to be on whether the agencies have overextended themselves. And whether, you can arrest a person, but to keep a person in jail for 6 months and to use technicalities to extend the bail at a time of elections will come into focus. And there's a lesson in that for the BJP as well. Ishkaran.
Arnab, two short points. First, because we are discussing the merits of the case, please appreciate the conditions imposed by the Supreme Court while giving bail. They are, you will not sign a file, not go to the secretariat. Anybody with any moral standing, 1 second, I didn't interrupt anybody, Arnab, because we are discussing merits now. I need to say these are the order. So anybody with an iota of morality would have resigned, because prima facie, forget Supreme Court saying there is no case against you.
I'll allow a counter 10 seconds to Anmol. Anmol, 10 second counter.
They have also
only two. Anmol.
Like this, which nobody wants to discuss.
Anmol, louder.
What does that
lost your mind?
What does that condition mean?
You have
What
no
is the
respect
impact
for
of
the
that
Honorable
condition?
Supreme Court.
And because a political party,
You are saying that forget what Supreme Court has said.
Started on morality. What is the morality?
You are a practicing advocate, Mr. Bhandari. कैसी बात कर रहे हैं आप? You must apologize to the Honorable Supreme Court.
You can come in. Whosoever is interrupting can come in.
What is he saying? You are allowing him to continue?
I have been on your debates, and I have consistently said that because multiple
no
summons
regard
were
for the
given,
Honorable Supreme Court.
and it was not arrested. I that time also said, if an ordinary person gets 2-3 summons and he evades them without a stay order.
Okay. Having said that, it is Kejriwal's day today. Give him that. He's out on bail. What I am interested in seeing right now is how actively and independently of the Congress he participates in the Haryana elections. The political import of the judgment, ladies and gentlemen, is that watch out in the Haryana elections. What is the implication of Arvind Kejriwal's coming out in the Haryana elections, and for the Aam Aadmi Party to strike an independent line in Haryana and Delhi after Punjab? That's what I'll look out for. I'll see you tomorrow. Good night and goodbye.
For a quick breather. Arnab will be right back with the debate.